So, can you foresee that if they half drain the pool, someone can get hurt? That's iffy. But if we get to the next thing, what would a reasonable person do with their pool in the winter? What?
They winterize it.
And that means? Half
draining it.
Half draining it, folks. This is exactly what people do with pools. Is it unreasonable to do what everyone else does with pools? Nope. Didn't work. What? What's the choice? Walk your way backwards, folks.
The choice on part of the plaintiff or the defendant?
It's going to be the defendant who gets sued. What did the homeowners do? What's the choice?
They should have put up a sign or something.
A sign? They should have a sign on their fence, say, please do not climb up on our roof, run along it, and jump in the pool.
Or inform that it was
Didn't they tell the people to stop?
They should have
yeah, but
covered
they
the
didn't
pool.
inform on.
When?
Once they're over.
Maybe they did and the other people. I don't know about that fact, okay? We don't have facts on that. What?
Whether or not to throw a party.
Is it unreasonable to have a party? Really? We're getting pretty far afield. What's their choice, folks? There has to be a choice. Actually, you're not as far off as I made it sound.
Leave it past the roof unobstructed.
So, should they put up barriers up on their roof?
No, to avoid the accident or cover the pool.
No. The covering of the pool was never an issue. I don't know whether or not... I don't think it would be unreasonable to leave your pool uncovered in September, even though you've half drained it, because people aren't supposed to be using it, right? What's the choice? Walk your way backwards, folks. What was the harm? What was the harm? Yeah, quadriplegic, right? So now you have to get to a choice that the defendants that is connected to that. What's the choice?
Would a reasonable person invite the specific person to go? No jumping?
No diving.
Who caused the harm?
Yeah, there has to be a connection. What's the homeowner's choice that you could connect to that action of jumping in the pool?
Providing alcohol.
Yeah,
Alcohol.
Or allowing the consumption of it?
to that point, right? Can a reasonable person foresee that if they allowed people to drink beyond where they have control, to the point where they're a little careless, somebody could get hurt? Can you foresee it?
Yeah.
So, everyone knows that alcohol causes people to do things they wouldn't ordinarily do. And if you allow them to drink past that point, they could do things that they would not normally do, and that could be dangerous. And since everyone knows that, it's foreseeable that allowing people to drink to that extent, somebody could get harmed.
Because they didn't have a brain.
What would a reasonable person do? This is the homeowner now. What would they do? Quit them. Don't let them drink that much. Right? And they didn't stop them. Was there harm? Yeah, the guy's a quadriplegic. And if they had cut them off, this is the question, before they reached that point where they were prepared to do stupid things, would they still be doing stupid things and jumping off? Would they have done that if they were sober, do you think?
Probably not.
Probably not. So they sued them. And they won. The defense that is raised is called contributory negligence. The basic test for this is, was the plaintiff stupid too? What's your answer in this circumstance, folks? Was the plaintiff stupid too? Was the guy jumping stupid to be jumping off the roof?
Yes.
Yeah. But contributory negligence is not a full defense. We talked about two of these, right? Remember provocation? Do you remember, did we talk about provocation?
No.
No? Okay. There are two defenses. One is a general defense, and one is a specific defense. They're both partial defenses. Provocation is where the actions of the defendant the actions of the plaintiff caused the defendant to lose control. So it could be yelling at them or, come on, punch me. Come on, punch me. You can't punch me. You're a sissy, right? And next thing you know, the person punched them. Should they have punched them? No. But that would be provocation. And provocation has the effect of reducing damages. They would maybe cut it in half. Yeah, you shouldn't have punched them, but we understand why you did that. They basically caused you to get so upset that you kind of lost control, and the person's partly responsible. So provocation is a partial defense. So is contributory negligence. So with contributory negligence, what they do is they try to determine how stupid was the defendant and how stupid was the plaintiff. So in this situation, folks, this is just your opinion now. There's no right answer. Who was stupider? The guy jumping or the homeowner? So the court agreed with that. So if we have to allocate percentages, which is what we do with contributory negligence, how stupid would you say the plaintiff was, the guy jumping, and how stupid would you say the defendant was, the homeowners? What percentage would you give to each? 60-40 I've heard. What? 70-30?
Yeah.
You happy with that? 70-30? Maybe even 80-20, you'd say? Because it was pretty stupid, right? Well, the court actually went higher. They actually went 90-10. And what happens is that if the damages are $10,000, but there's contributory negligence, the plaintiff has to absorb 90% of that. And the defendant has to pay 10%. This is why it's a partial defense. You still have to pay, just not as much. That's what a partial defense does. That's what provocation does. That's what this does. So if it was $10,000, how much does the plaintiff have to pay? $1,000. Do you think it was $10,000? No, it wasn't. It was $20 million. So that was the bad news. The good news is the plaintiffs only had to pay 10% of that. And how much is that? Do you have $2 million? Check your pocket. Maybe your mom gave you your allowance. You never know. Oh, there it is. Yeah. Right? Do you have $2 million? Do you have $2 million? I'll take a check. All right. So, $2 million, folks. These people had a house. It was worth a bit of money. They had cars and everything else. But the sum total of their assets was probably closer to $1.5 million. Can you just hold it for a second? Okay? So what happened to them?
Bankrupt.
They lost everything. Everything. They lost their house, they lost their savings, they lost their retirement, they lost their pensions, they lost everything that they owned. Everything. So I just want you to understand this, folks. I want you to imagine this, okay? I want you to imagine that you get home tonight, and you will get home tonight, and your parents phone you up, and they say, we've got some rather unfortunate news. We've just been sued, and they've taken everything we own. Our house, our car, our money, our savings, our future. It's all gone. Why? Because we were 10% negligent. And the law is not nice. The law is not kind. The law is not fair. The law is a harsh bitch. And it will take everything. And there's nothing they can do about it. It's gone. That, boys and girls, is why you're here. because it can happen to you. You can lose it all as a result of a second of carelessness. And that's the way it works.
I just wanted to make sure I didn't mishear you or didn't speak. I heard you say the plaintiff was assigned 10% responsibility.
I should have said the defendant.
Okay.
Yeah, it was 1910. So the judgment was the damage, leaving someone a quadriplegic, loss of income, having to have a care, having to have a special vehicle, everything else. The judge totaled up the loss and said it was $20 million. And this, by the way, was probably 20 years ago. It'd be way higher than that now. Plus pain and suffering and aggravation and not being able to play the piano again. Having 24 hours medical attention because you can't go to the bathroom, you can't do anything. The judge added up all the loss, and it was $20 million at the end of when we did the math. But he said you're 90% responsible, and the defendant only had to pay 10% of it. But it doesn't matter. Whether it was 10%, 20%, 50%. When you're talking these numbers, when you're talking this amount of loss, it's super high. Right? And they lost everything. And sometimes students will ask me this question, and it's a valid question. Why don't bars get sued? Do you know that there's a law that says it is against the law in Manitoba to serve someone alcohol when they are under the influence of alcohol? At what point, folks, would you say you're under the influence of alcohol? How many drinks? One? Some of you might go, oh, not really that bad. Until what? 3? Right? And does the bar say, that's it for you?
No.
You're under the influence? What do? You could be, how many times you've seen someone at the bar and they're just freaking blotto? Right? And they go by, they walk out with 2, right? And if it's illegal to do that, is it unreasonable to do it?
Yes.
Would a reasonable person, position of the bar, foresee that if they give people too much alcohol, someone could get harmed? What would a reasonable bar do? Especially when it's against the law. Not do it. Was there harm? Yeah, there's tons of harm. And if you cut the person off, would they still have been harmed?
Yeah.
This caused the harm. Giving them too much alcohol was a factor often in a lot of things that happen. And I don't know why bars don't get sued. It's just because we don't sue people in Canada. Not that much.
So, do people get to that point? One guy decides to bottle somebody else. The guy that gets bottled could actually sue the bar for that.
Sure. Absolutely. And, this is to me self-evident. The big thing is that where do people mostly get hurt when it comes to alcohol? When they drive. And in Manitoba, you cannot sue for motor vehicle accidents, no matter how they started. So you can't get them for that. But, people who freeze or fall asleep or whatever, or slip and fall and hurt themselves, this is all, to me, easy peasy negligence. So, we have these issues. I'm not going to be able to get there. Okay. I just want to tell you something, because I'm going to ask, I've got a few trailers that are left over here, okay? I need to deal with categories of negligence, but it's going to take me more time than I have. I just want you to know that there's some specific types of negligence, but none of them change anything that we've talked about. These are the elements. These are what you write. I don't care what type of negligence, you'll write the same thing. It doesn't matter. So knowing those is not ever going to change your answer. It just allows a little bit of certainty. So I'm just going to tell you what one of them is, and then I'm going to get you to go through the rest of them next time. So there's something called occupier's liability. Occupier's liability is a type of negligence. It basically says people are responsible for the building or the premises that they occupy. So the university's responsible for this place, right? So if they left a piece of carpet loose here, and I tripped on it and banged my head and smacked into your head, and we both hurt our heads, okay? Real bad, okay? You couldn't be a student much longer, and I was done teaching because we whacked our heads, right, because of the carpet. Well, that would technically be occupier's liability. It's the requirement to maintain and take proper care of the building that you are occupying. But if I never told you that's called occupier's liability, we would go through this the same way, which is, would a reasonable person foresee that if they leave a piece of carpet loose where people walk, someone could get hurt? Is it foreseeable?
Yes.
What would a reasonable person do? They would fix it. Did you fix it? No, you left it here. Was there harm? Yeah, she and I smacked our heads, and we're both hurt. And if you'd fixed the carpet, would I still have fallen and tripped? And the answer is no. I'm not that bad of a... I haven't reached that age of life where I can't balance myself on 2 feet, right? It was because of the carpet. That's why I fell. Your choice caused the harm. You'd be able to sue. Although that's called occupier's liability, it's just negligence. It doesn't change anything. So I'm going to talk to you a little bit about a couple of different types of negligence. But the one thing I want to talk to you about tonight, I still want to get through. There's 2 tiny points. They're endpoints for this. I'm going to have to go back and tell you a little bit more about negligence next time, but I want you to walk away understanding these 2 points. The first one is about suing governments. There's a rule about suing. And the rule is this. You can't sue yourself. Right? So if I stand up here and go, battery, Murray, I'm going to sue you, right? And battery, I'm going to sue you. And you know what? I'm going to try doing some tricks here. When I fall and whack my head, I'm going to sue myself. Can I sue myself?
No.
No, I can't sue myself. This translates somewhat into suing governments. Because who is the government?
Elected officials.
By who elects them? We do. We do, right? Even though you didn't vote for those morons, we still elected them, right? And because you can't sue yourself, you also can't sue the extension of yourself for the choices they make, because effectively, they're your choices. So the way this works is you cannot sue governments for the choices that they make, because they're making those choices on behalf of the people. And the people can't sue them for those choices. So let me show you something here, okay? If the government decides not to plow streets, okay? They make a choice that they're not plowing streets. It's too much money, we can't afford it. Could a reasonable person foresee that if they don't plow the streets, someone could get harmed? Everyone knows that if you don't plow the streets, people lose control, they can plow into things and lose harm. Did they fail to act reasonably? What would a reasonable person do? Well, given that harm, they would plow the streets. Did they? No, they failed to act reasonably. Was there harm? Yeah. I was driving along and I hit this snowbank because it wasn't plowed, and I cracked my car and hurt myself. And if they had plowed the streets, would I still have been hurt? No. They're failing to act reasonably caused my harm. But you can't sue a government for that. If they're making a choice. What you can sue them for is if they choose to do something and then they do it badly. So if they say we are going to plow the streets, but they plow them badly, you can sue for that.
Right.
I think the choice not to plow the streets in Brandon, holy crap, I was up over in the east side, it was pretty bad. Okay, so governments can't be sued for the choices they make, but they can be sued when they make a choice and they do it badly. So how they do things, they can be sued for. Okay, sometimes. So I want to finish in the last 2 minutes that I have, folks. I might keep you just a minute longer, okay, because a very small point is an extremely important one. Okay? There is something called vicarious liability. Vicarious liability is a way, it's not a tort. Okay, it's not a tort. It's a way of getting an employer to have to pay. And it applies to all torts. So what you have to show to establish this is an employee committed a tort. Any tort. And what they were doing, not how, was part of their job. When you prove those two things, you can get the employer to pay for the loss if you're the plaintiff. And this is absolutely wild because there's nothing you can do about it. So I want to finish, if you just give me a minute or two, okay, with the leading case on this, because it shows you how extreme this is. There was a case out of BC. It was Child and Family Services, and they had a group home. And what was happening at the group home was that these kids were being sexually assaulted by the workers when they put them to bed. Okay? So in course of putting these kids to bed, they were fondling or doing something with the kids. And the kids end up suing. But they went after the government of BC for vicarious liability. And the government of BC said, what are you talking about? So the first question is, did the employees commit a tort? The answer is yes, it's battery. Okay? The second question is what they were doing, not how part of their job. And what BC said was, this isn't part of their job. We don't hire people. We train them, we screen them, we do everything right. That all proves that they weren't negligent. But we don't deal with that with vicarious liability. We're not trying to prove a tort. We're trying to prove that the employer has to pay. It's not a tort. So they said, this is not part of their job. And they said, you're talking about how they did it. What were they doing, folks? They were putting the kids to bed. Is that part of their job?
Yes.
That we don't care how. How, if you show that what they were doing, not how, was part of their job, the employer has to pay. And there's absolutely nothing an employer can do to protect themselves. They commit a tort, you're done. If what they're doing, not how, was part of the job. Even if you train them, even if you tell them, even if you screen them, even if you monitor them, even if you do everything right, you still have to pay. And in that case, it was $4.3 million. I want you to ask me to explain that further next week. I want you to ask me to deal with the categories of negligence next week. And for next week, I want you to please, please, please try to go through the case study. All of them, because we never got to any of them tonight. I want you to find intentional torts and unintentional torts. I want you to analyze them according to the process. I want you to ask this stuff for negligence. I want you to answer it fully as if it were on an exam. This will take you probably a couple of hours if you do it right. Spend some time working on it. And we'll sort it out next week. I told you it was going to be a full night. And it was.